Supreme Court of the United States is now in session. All persons having business before this court, draw near, give attention, and you shall be heard. God save the United States of America and this honorable court. You may be seated.
Good afternoon, ladies and gentlemen. Welcome to this court. We have granted review of the appeal from the Supreme Court of the State of Olympus in the case of William Denoff, Jr. versus the State of Olympus on the certified questions on the 4th, 8th, and 14th Amendment of the United States Constitution. My name is Judge E.J. Salsinas, and I've been given the privilege this afternoon to serve as the acting Chief Judge of this distinguished panel of experienced jurists.
Mr. Chief Justice, and may it please the Court, good afternoon, Your Honors. My name is Siva Casanathan, and along with my co-counsel, Catherine Willey, I represent the State of Olympus, the petitioner in the case of Barr. May I reserve a minute of my time and a minute of my co-counsel's time for rebuttal?
Yes.
Mr. Denoff the State of Olympus respectfully asks this Court to reverse the lower court's judgment and find that the warrantless search using the visual enhancement device known as the Cyclops 237 and the sentencing of Mr. Denoff to life in prison without parole is constitutional under the 4th and 8th Amendments, respectively. I will address the first question regarding the 4th Amendment. Now, the lower court incorrectly held that search using the visual enhancement device was unconstitutional, and we ask this Court to reverse for two reasons. First, respondent's 4th Amendment claim must be facially rejected because he does not have a reasonable expectation of privacy under the 4th Amendment. And second, the pre-warrant search using the Cyclops 237 is constitutional under the 4th Amendment, even if this Court does find a reasonable expectation of privacy. Now, first and foremost, respondent must prove a reasonable expectation of privacy under the 4th Amendment in order to make a 4th Amendment claim. In Minnesota v. Carter, this Court ruled that an individual must show a subjective expectation of privacy that society is prepared to recognize as objectively reasonable in order to make a 4th Amendment claim.
Well, wasn't this RV owned by his stepfather?
Yes, Your Honor, the RV was owned by the stepfather, as the record notes on page 3. However, as this Court ruled in Minnesota v. Carter, citing Minnesota v. Olson, the respondent necessarily doesn't need to own the property in order to have a privacy interest. Further, this Court also notes in Oliver v. United States that a property interest alone isn't enough to satisfy a privacy interest.
Let me ask you, isn't an RV more like a vehicle as opposed to a home?
No, Your Honor, RV cannot be considered an automobile for the purposes of 4th Amendment analysis. Specifically, in California v. Carney, this Court found that an RV can be considered an automobile subject to a lower expectation of privacy under the 4th Amendment as long as it meets two criteria. First, the RV itself must be readily mobile, and secondly, the RV must be in some way configured or in a situation that suggests its use for transportation. In the case of Barr, the RV meets both criteria in order to satisfy this automobile exception to the 4th Amendment. Specifically, as a record notes in page 4, page 3, the RV itself is readily mobile as long as the tires are inflated, meeting the first of the Carney criteria. Secondly, the RV itself is configured for transportation because the RV had to have in some way been transported to get to its current location on the 25-acre lot. Further, even if this Court finds that the RV is not readily mobile, it must find that the RV is an automobile, meeting the automobile exception of the 4th Amendment under Katie v. Dombrowski, as cited within Carney, because the RV at one point in time had been mobile or has the potential to be mobile. So therefore, there is no reasonable expectation of privacy in the RV that is afforded to respondent Denoff, and as such, he fails to meet this minimum constitutional burden under Minnesota v. Carter to make a 4th Amendment claim. As a result, this Court must reject his 4th Amendment claim facially. However, even if this Court finds that Mr. Denoff has a 4th Amendment claim and a reasonable expectation to privacy under the 4th Amendment, the pre-warrant search using the Cyclops 237 visual enhancement device is constitutional under the 4th Amendment. Now, a search under the 4th Amendment, according to this Court's decision in Katz, occurs whenever a reasonable expectation of privacy is infringed and generally requires a warrant. Now, in Kylo v. United States, this court articulates a two-pronged test for determining whether a sense enhancement device is constitutional under the Fourth Amendment without a warrant.
Props 237 device readily available to the general public?
Yes, Your Honor, it is.
How so?
The record at page 4 specifically notes that the Cyclops is available to the general public through various distributors and catalogs. Now, as a result, it meets the second of these the Kylo criteria.
Hold on a second, I thought it was used primarily by military people, not by the general public.
Your Honor, the record specifically notes that the Cyclops device is used by bird watchers, members of the general public, for their own enjoyment and their own use.
So it's your argument that because certain parts of the population use it, like you said, bird watchers, that it's available, generally speaking, to everybody?
That's correct, Your Honor. Further, in Florida v. Riley, this court found that a helicopter search of a property was reasonable because helicopters in general were a mode of transportation that was generally accessible to the public. Similarly, in the case of Barr, the Cyclops is something that is generally available to the public through, again, various catalogs and distributors, and as a result must be found as a constitutional search, a constitutional sense enhancement device that can be used without a warrant under the Fourth Amendment under the Kylo criteria.
Let me ask you this. If we disagree with you that the search is invalid, where does that leave the state? We say that the initial search with the Cyclops without the warrant is invalid. Where does that leave the state?
Your Honor, even if the initial search without the Cyclops is invalid, the problem is that respondent needs to show a reasonable expectation of privacy in order to qualify for Fourth Amendment protection. The fact of the matter is, in the case of Barr, respondent simply doesn't have a reasonable expectation of privacy. Now, the first of the reasons is because the RV itself cannot be considered a home and must be viewed as an automobile. Now, secondly, the RV is a property used for business purposes and is not a home as such where a high expectation of privacy under the Fourth Amendment can be expected. Now, specifically in Minnesota v. Carter, this court, citing Berger v. New York, noted that an individual has a lesser expectation of privacy in places of business, most notably due to the extensive regulation of businesses by the government. And O'Connor v. Ortega, as cited within Carter again, an employer-employee relationship is necessary in order for an individual to claim Fourth Amendment protections in a workplace. And again, in the record, there's no evidence indicating that Respondent Denolf is an employee of the workplace in question, the RV. Now, the RV must be considered a workplace for two specific reasons. First, at page 3, the record notes that the RV has power usage, electricity usage, that is inconsistent with a home, and that police initially suspected the RV because of its power usage of being a place where marijuana is grown for commercial purposes. Furthermore, on page 4, the record notes that over 100 tomato and bell pepper plants were grown in the RV, and it's reasonable to conclude that these bell pepper plants were not grown for consumption solely by Mr. Denolf's family. As a result...
Is the state suggesting there's something illegal or untoward about growing bell peppers and tomatoes?
No, Your Honor, there isn't. The only significance of the growth of the tomato and bell pepper plant is that they're grown for commercial purposes, establishing that the RV itself is used for a business purpose and as a result doesn't qualify for heightened Fourth Amendment protections. Now, because the RV itself doesn't qualify for heightened Fourth Amendment protections, the fact of the matter is, in the case of Barr, respondent simply doesn't have a reasonable expectation of privacy. Now, the first of the reasons is because the RV itself cannot be considered a home and must be viewed as an automobile. Now, secondly, the RV is a property used for business purposes and is not a home as such where a high expectation of privacy under the Fourth Amendment can be expected. Now, specifically in Minnesota v. Carter, this court, citing Berger v. New York, noted that an individual has a lesser expectation of privacy in places of business, most notably due to the extensive regulation of businesses by the government. And O'Connor v. Ortega, as cited within Carter again, an employer-employee relationship is necessary in order for an individual to claim Fourth Amendment protections in a workplace. And again, in the record, there's no evidence indicating that Respondent Denolf is an employee of the workplace in question, the RV. Now, the RV must be considered a workplace for two specific reasons. First, at page 3, the record notes that the RV has power usage, electricity usage that is inconsistent with a home, and that police initially suspected the RV because of this power usage of being a place where marijuana is grown for commercial purposes. Furthermore, on page 4, the record notes that over 100 tomato and bell pepper plants were grown in the RV, and it's reasonable to conclude that these bell pepper plants were not grown for consumption solely by Mr. Denolf's family. As a result...
Is the state suggesting there's something illegal or untoward about growing bell peppers and tomatoes?
No, Your Honor, there isn't. The only significance of the growth of the tomato and bell pepper plant is that they're grown for commercial purposes, establishing that the RV itself is used for a business purpose and as a result doesn't qualify for heightened Fourth Amendment protections. Now, because the RV itself doesn't qualify for heightened Fourth Amendment protections, we need to evaluate whether Respondent Denolf has a reasonable expectation of privacy in the RV. Now, in order for Respondent to make a claim, a Fourth Amendment claim, in the RV considered a business place, he needs to demonstrate that he's an employee of the business. However, there's no positive evidence in the record indicating that he's an employee. In fact, the record at page 3 only notes that the Respondent's stepfather and his business associate were involved in the growing of the tomato and bell pepper plants. As a result, because Respondent Denolf is not an employee of the business, he cannot make a Fourth Amendment claim and does not have a reasonable expectation of privacy under this court's decisions in Berger v. New York and O'Connor v. Ortega, again cited within Carter. As a result, because Respondent doesn't have a reasonable expectation of privacy, his Fourth Amendment claim must be facially rejected by this court, and this court must find in favor of the petitioner and reverse the lower court's decision.
Mr. Chief Justice, and may it please the Court. Good afternoon, Your Honors. My name is Catherine Willie, and I, along with my co-counsel, Siva Castanathan, represent the petitioner in today's case, the State of Olympus. Today, the State of Olympus respectfully requests that this Court overturn the lower court's decision. I will be addressing the second question presented to this Court today, and the Eighth Amendment. Today, the State of Olympus respectfully requests that you overturn the lower court's decision for 2 reasons. First, because the standard of gross disproportionality that triggers proportional review under this court's decisions for Eighth Amendment was not met. And second, because even if you think that this gross disproportional standard was met, then this case and sentencing surely need proportional review under the precedent set by this state. Now, specifically, in order to determine whether or not something needs proportional review, this court has articulated several different tests. But if we look recently to the test articulated in cases such as Kennedy and Ewing, we can see that it differentiates and draws a hybrid kind of test from cases such as Solem and Harlem. Specifically, this court argues that there is a threshold analysis that's required, that an individual must first show that a sentence needs cruel and unusual punishment before they examine the second and third prongs of the Solem standard, as articulated by Justice Kennedy in his decision in Kennedy. Specifically, in order to determine whether or not something meets this threshold standard, the court has traditionally weighed the severeness of the sentence versus the harshness of the punishment.
Now, wasn't in that case involved a sentence of death as opposed to this case, which is a life sentence without possibility of parole?
Yes, Your Honor, Kennedy did involve a sentence of death, however, Ewing did not. And specifically, this court has addressed this changing policy in the light of non-capital cases as well, in an attempt to resolve some of the discrepancies between Solem and Harlem in order to create some kind of bright line. So while Roper and Kennedy didn't specifically speak to non-capital cases, they did help articulate a clear test for this court to follow in those type of cases to determine whether or not proportionality should be reviewed. Additionally, if this court decides to only follow the test that's articulated in Harlem, it's still important to note that the concurrences in Harlem, which have mostly been followed by this court, also examine this idea of threshold analysis that is articulated, which weighs the severeness of the punishment versus the nature of the crime committed.
Let me ask you this, is life without parole for a juvenile the ultimate punishment?
Yes, currently, after this court's ruling in Roper, it is the most severe punishment that a state can inflict.
So can we analogize the Supreme Court, our other precedents with this case, given the fact that this is the ultimate